Now it's time to introduce our two speakers. Robert Norland is the president of Association Reserves and a registered professional engineer. Robert is also a certified reserve specialist, was involved in creating national reserve study standards, and has greatly influenced this industry for the past 27 years. He regularly writes on the topic of reserve studies and speaks at industry functions throughout the nation. Association Reserves has prepared over 30,000 reserve studies for association governed communities throughout the United States. Robert is often called to serve as an expert witness in litigation involving reserve issues. Adrian Adams has an MBA from UCLA and his Juris Doctorate from Southwestern Law School. Adrian is founding partner of the Adams Kessler Law Firm and practices law in California, specializing in common interest developments. Adrian writes and publishes a popular weekly newsletter to a national audience, through which many of you learn of this webinar, with analysis and commentary on legal trends in this industry. Finally, Mr. Adams created and writes content for the davissterling.com website, an award-winning resource specifically for the California Community Association industry and the largest website of its kind with thousands of pages of content. And now I'd like to turn the floor over to Robert Norland. Robert?
Paige, thank you very much. It's a pleasure to be with you all today. Adrian, can I get you to say hello?
Hello everyone, and welcome to the webinar. We look forward to presenting you with some really interesting information and answering your questions.
Fantastic. At this point in time of the year, we're in September. This is often what we call the busy budget time of year, and there's so many associations looking at their budget preparation process for next year, looking at completed reserve studies, and in going through client questions, we were realizing how significant the legal side of the answer is to the question, how much should I contribute? So with respect to the question of are we contributing enough, there's not only a financial aspect to this, but a legal aspect to this. So that's why we wanted to put on this webinar and address the depth of the issue, how much am I contributing, and then leading to the title of today's webinar, Ignoring Your Reserve Study. We're going to set the table by, as Paige indicated, dividing the topic into three different parts. Selling out, which is totally ignoring the advice in the reserve study, basically just doing what they've done before. Settling, which is moving towards the reserve contribution recommendation, but not following the recommendation. That might be making a minor adjustment, that might be making a contribution, something that we call baseline funding, that is just contributing enough to stay cash positive. Or it may be what we're calling succeeding, and that's following the advice in the reserve study to be fully funded. And that means a reserve fund that is equal in size to the value of deterioration. It's a lot more than zero. It ends up meaning that an association has a much lower risk of a special assessment. Now, as Paige had indicated, we have a few people who have emailed in questions in advance. If you have a question that comes up at any point in time during today's session, this is what it looks like in your control panel box. Please type in your question. Paige will be monitoring that during today's session. And if at any point in time Adrian or I need some feedback on an issue, we'll ask you to raise your hands. So you'll, at that point in time, reach for your mouse and click on the little hands raised icon. So let's practice that right now. If everyone's ready to go, give me a hands raised. Click on that hands raised icon. Great, I'm seeing hands raised all across. Okay, I'm going to put everyone's hands down and we'll move on with today's content. Okay, I need to first start with a little bit of background to set the stage on our conversation. The reserve study comes in three parts. You get three things in a reserve study. You get the component list, which is the disclosure of the physical status of all the components, the useful life, remaining useful life, replacement cost. We call that the foundation of the reserve study. There's the calculation of reserve fund strength that is done next. That's a calculated disclosure of the size or strength of the reserve fund, revealing if the association is behind or on track with respect to how much it has in the bank at this point in time. And finally, we get to the third result of a reserve study, oftentimes the result that people go to first. That's the reserve funding recommendation. It's a multi-year plan to offset those irregular expenditures with a steady income stream, ideally so every owner pays their fair share of the ongoing deterioration. In today's discussion, we're going to be focusing on that funding plan. Is the board following, or I should say, selling out, settling, or succeeding with looking at the funding plan? Another thing to mention is that we are going to address just national principles at this seminar today. There's 30 states that have reserve requirements, but we're going to talk about national reserve study standards. And in addition, there's some specific state requirements that have requirements for when a reserve study is prepared, how often, what kind of interval. So not only type of reserve studies and the terminology, but when they're done and specific requirements. We're not going to try to get into that level of detail, but just stay speaking about national type standards.
We'll talk about the things that go across the board dealing with fiduciary duties of directors, because as board members on these on association boards, both incorporated and unincorporated directors have the same basic duties dealing with how they handle the oversight of the association and one of their primary functions, which is the maintenance of the property. And that's where reserves come in. So we'll talk about those general principles that will apply across the board. The board member responsibility is described in actually 3 different areas, 2 areas under the law. One is the statute, and what Robert was referring to is under the condominium laws in various states dealing with reserves. They may have varying requirements as to timing of studies and what's required to be in them. And I'm not going to go into any of those. I'm going to deal with and focus primarily on the fiduciary duties, which tend to arise out of the Corporations Code, the case law, and then CC&Rs. And the CC&R requirements, I think almost all 3 areas are all going to require basically the same thing. That is that associations maintain the common areas. And the associations do that through their boards of directors. And the boards of directors have to have the money in order to do that. The question is, how do they get to that money? And that's where the reserve studies come in, and that's what we're going to talk about. Okay, the business judgment rule is one of those rules that applies across the board in all states. And the elements may vary slightly from state to state, but generally these are the basic 3 legs of the stool. And what the business judgment rule does is it protects boards of directors from personal liability if the decisions that they make follow these 3 elements. So they can make a mistake that results in a lawsuit against the board and against the association, but they're not going to be personally liable if they follow the business judgment rule. When they don't is when they get into trouble. And so the 3 elements is that their decisions on behalf, for example, dealing with reserve studies, must be made in good faith, in the best interest of the association, and after reasonable inquiry. So if they do those 3 things, and we'll talk about that in a little bit more detail as we go along, then they avoid personal liability even if somebody were to sue the association. So Robert, there we go. So we'll talk about the danger areas, and in fact, do you want to talk about some of those right now, Robert?
Certainly, I'll move on forward. We've got a risky situation here. As indicated earlier, it's not just the finances, it's not just the budget type of issues, but there's a lot of implications as far as liability, and that's why we've got Adrian here today. So we want to make sure that you're aware of the riskiness of the decisions that you're making at this point in time. We're going to have go ahead.
Yeah, just in general, bad decisions related to the reserves will have a lot of fallout, and we'll detail those. We'll provide more details on what those are as we go along. But the decisions that you make as boards really do impact the association and its exposure to risk. So yeah, let's look at an example here.
Okay, the kind of example association that we're going to talk about today is a pretty typical association. 80 units, very close to the national average. We're going to presume that they are making reserve contributions of $2,500 a month, and they get a reserve study that says you need to be recommending twice that, $5,000 a month. And just to give you kind of a reference point, that's a full funding recommendation. A baseline funding recommendation, which is a recommendation to just barely have enough reserves to keep your reserve fund cash positive, is $4,350 a month. So you can see that at $2,500 a month, they're not contributing enough to keep their reserves cash positive in order to do all their projects on time. So they need to be contributing above $4,350 and likely closer to $5,000 a month in order to have enough cash to make things happen.
Yeah, let me jump in and ask a question. Okay, when you say barely cash positive, what does that mean?
Well, we're projecting expenses out into the future. When an association is trying to plan its reserve fund, it's looking at how much money do I need, and if they plan to just barely have enough cash to keep the reserve fund cash positive, that doesn't involve any margin for the uncertainties, the reality that the future is going to happen different than our best laid plans. And so what we find is associations that pursue full funding, where for argument's sake, if you have a pool that needs to get resurfaced every 10 years and it's a $10,000 cost, we would recommend that at the 5-year point, when the pool is halfway, the life is halfway used up, it's a good benchmark that you have roughly $5,000 set aside for that project. So that's full funding. You're making progress along the way. It's a measurable ability to see, am I on track? And that's different than just waiting for the 10th year and crossing your fingers that you have $10,000 in the bank account so what you can spend that 10 grand and not go negative. Does that help?
Good, yes, thank you.
Okay, so that's the situation that we're going to talk about today. The rest of the actual numbers are that these are what we see as the real consequences, the minefield issues that we want you to dodge. Special assessments, deferred maintenance, mortgage difficulties. We've had recently more banks calling us, confirming the numbers in the reserve study and saying that unfortunately they're now going to have to blacklist that association and not extend mortgages at that community association. That's a hard phrase to hear, but sometimes that's the reality of what an association is doing. There's declining home values, there's board liability exposure, and as I led off earlier, this is much more than just finances.
Yeah, let me add to that as well. My experience with this is dealing with number 5, and that is basically, that means litigation. If the association is badly underfunded in their reserves, what is going to happen inevitably are special assessments. And the worse the condition of the reserves, the bigger the special assessments. And when that happens, people are going to be looking at, especially those who don't have the money, and they're being threatened with lien and foreclosure if they don't come up with it, they're going to sue somebody in order to avoid having that happen. I've been involved in litigation in a number of lawsuits where we've defended the association against the litigation, where they've been underfunded in their reserves. And the risk of litigation is very real. And you don't want to be in a position where you expose yourself as directors to potential liability and the association. And then the other thing is on the declining home values. They'll either decline, or at least in California, they hardly ever decline. They may be flat because of the underfunding and the deferred maintenance. And I've seen that there are more sophisticated buyers now that are looking at the budget, and in particular the reserves, because badly underfunded reserves means that a special assessment is going to happen. And a buyer is not going to want to be in the position where they are going to get hit with a special assessment, and lenders don't want to lend if their buyer is going to get hit with that assessment and not pay their mortgage. So all of these things are wrapped up into the funding decisions that boards make when it comes to reserves.
Thanks, Adrian. One thing I want to emphasize is that these are current decisions. We're talking about decisions that you make this year for next year's budget. I want to encourage you to not think about reserves as a future issue, future expenses that you can defer. These are very real things that are happening right now at this point in time. And the decisions that you're making, you realize that you do have options. You're, as a board member, in charge of making decisions. As a manager, you're a counselor. If you're a homeowner, you're subject to what the board decides for you. There's lots of choices out there, and we want to help you avoid any of these that are poor choices. One more thing to discuss as we set the table here is that we're presuming that you have received advice, that you have recently received an independent, professionally credible, prepared reserve study. And in the words that Adrian spoke earlier when he was talking about the business judgment rule, you've reached out and made reasonable inquiry. So presuming that you have that current reserve study, you've looked for advice, now we get to the first topic of today, ignoring, selling out. What happens when the association just doesn't want to do it? Adrian.
Well, the consequences, I mean, we've already described in what all the potential consequences are, from the special assessments to the litigation and flat values, home values. But, you know, the question comes up, are there legitimate times when a board can say, I'm sorry, we understand your recommendation of taking it up to 5,000, but we're not going to take it beyond the 2,500 that we're doing. That doesn't happen very often. It's a very rare time that you could actually legitimately ignore the advice. And the best example of that is the 2008 crash of the housing market, and then the foreclosures that started occurring that left associations with their budgets slashed dramatically because
Crippled.
people, essentially, yes. And they did two things. What happened was they stopped contributing monies into the reserves, they deferred maintenance, and the third thing that they did was they stopped calling the lawyer. We saw it as well, big decline in the phone calls to us. But the impact from this is that this large growing amount of deferred maintenance and and no reserves in order to pay for it. But boards were in a position where they didn't even have money to operate, so their operational budgets were such that they were being crippled, and so they cut back in all those areas. But we are now in a rising market. We're in a recovery mode, even though it's still a weak recovery. The boards are looking at how do they get back into funding their reserves, and they're gradually stepping back into that and funding, maybe not at full funding levels yet, but they're at least starting to move monies into the reserve funds. So, Robert?
Sure. Well, the reality is, as Adrian was talking about, there's some real things that are happening, whether it's the economic situation. The other real things that are happening are just like the roof continuing to deteriorate. The roof doesn't care if there's a economic malaise or economic recession here in the country. The roof is still going to get a little bit older each day. So that's the real ongoing issues the association has to work with and figure out how they're going to deal with it. And Adrian,
the stuff on the roofs, they could band-aid, and a lot of associations were doing that. They were band-aiding their repairs, and so that they could extend the life of components. And roofs are one of the biggest ones where we've seen that. But we're now at a point where they can't do that anymore, and so the business judgment rule starts to kick in, and that is, if they continue to say no, then they're facing, in other words, we're not going to put any money, we're not going to raise dues, we're not going to add any more money into the reserves, then they are in danger of violating the business judgment rule. And I can tell you a really good example of a clear example of a violation of the rule would be someone who campaigns and says, vote for me because I'm not going to raise your dues, or in fact, I'm going to lower your dues. And then they get in, they sit down with the board, they look at the condition of the association, and they look at the recommendations on the need for reserves and reserve repairs, and they say, I'm not going to vote for this because I made a campaign promise. Okay, now that violates the good faith element of the business judgment rule and also the best interest alike. So you've got two elements here that are in violation. And the good faith element is generally regarded as, what does that mean, being in good faith? A conscious disregard of the consequences of your decision would be not in good faith. So they look at it as a negative. You're not in good faith when you make a conscious disregard of the consequences of your decision. So and if you're in violation of the business judgment rule and you get sued, you could become personally liable for those consequences.
Yeah, and those consequences, when you're in the selling out mode, or when you take that option of just not doing anything, you're exposed to all the consequences: special assessments, deferred maintenance, mortgage difficulties, declining home values, and as Adrian indicated, the board liability exposure. You've got home values that are either going down or not maximizing. It's
right, or not rising. They flattened out.
Right, they're just not going where they could. And another element in this part of the conversation is that special assessments are not, I want to encourage everyone to understand, special assessments are not just bad luck. You can measure them, you can measure the strength of the reserve fund, you can basically see them coming. So when you have a board member that is promising, I'm going to keep the assessments at last year's level, or roll them back to 5 years ago when I first bought in here and things were good, they're ignoring the reality that they're just deferring those same expenses to the homeowners having to pay them as part of a special assessment. The expenses don't go away.
Are these numbers from your experience, your company's experience with HOAs around the country?
Correct. This is the national profile of our client base across the country. So you can see on the left, as your percent funded gets lower and lower, basically as you have less cash in reserves, the chance of special assessment goes up. And the worse it is, the higher the chance. And I think, as you indicated moments ago, not only the higher the chance, but the bigger the amount.
The bigger the special assessment, too. Because the longer they defer, the less money they have in the reserves. That means a bigger special assessment. And the bigger the assessment, the bigger the risk that they're going to get sued.
Right.
And that's where I've seen it. A small special assessment, I've never been involved in any litigation over a small special assessment. They're always the big ones. And so the longer you defer, the longer you fail to build your reserves, you're going to get a big special assessment, and your risk of litigation is very high.
Right. The thought that we want to leave you at the end of the selling out portion of this webinar is that wishful thinking is not an effective plan. It's not a wise plan. The expenses are going to mount. They're going to continue to grow. And if you don't have the reserve contributions to offset them, you're just dooming your association to a number of poor consequences. So let me turn us into the next subject, which may be actually a little more interesting, the settling. What are they, where the board is actually making some strategic choices. They are realizing that they have some opportunities to make some changes, maybe not a whole lot of room. And for argument's sake, let's say that they're considering moving up to reserve contributions of $3,000 a month or $4,000 a month, something like that. The question is that a good or bad decision? On one hand, it could be good if they are deciding to do something in the best interest of the association, or it's bad depending on their point of view if they are trying to make the decisions themselves. Adrian, can I get you to weigh in on that?
Yeah, the decision to fund at $3,000 instead of $2,500 or $4,000 a month instead of $2,500, that is by far better than a decision not to fund at all. No increase at all when they're looking at a recommendation of $5,000 a month. So that is a good decision if there are, for example, you want to look at, I always look at the worst case scenario, they get sued and we're in court. And the question is, why did they choose to fund at less than $5,000, which was the recommended amount? Are there mitigating factors? We're still, coming out of a difficult recession, and it would drive a number of our residents into foreclosure and bankruptcy, which would negatively impact our budget. And so we're doing a partial measure instead of the full measure.
Let me move you on, Adrian, let me move you on to the next chart. It sounds like you're talking about exactly this. Is it in the best interest of the association, doing what they can, these types of issues?
Exactly. Yeah, because this is a good faith decision in the best interest of the community, because they're looking at it as a whole. Now, you're always going to have somebody that's going to say, no, you should be doing 100% funding, you should do it all the time. Well, there are conditions to consider where the association may still be very weak, the membership very weak, and that a full 100% funding is still not the best decision. I mean, it's ideal, but it still may have negative consequences. And as long as you're making those kinds of decisions and you're moving forward with the funding, then you're going to be protected, protected by the business judgment rule, and that's where you want to be.
Excellent. I have one more chart to illustrate that point. I didn't do the math earlier, but I'll pull out my calculator now. At $5,000 a month divided by 80 units, that's $62.50 per unit per month going towards reserves. When we find associations that are underfunded, that means that in effect they're not at $60-some per month per owner, and they may be at half of that, which was $30-ish per month per owner. You can see that if they can take a step in the right direction, if they can move that $30 contribution per month per owner up to $40, or in another way of speaking, if you can raise your homeowner dues $10 per month in 2015 and put all of that $10 towards reserves, you're going to start to make that path of progress. Likely you got into this underfunded situation through years of underfunding. You could argue that it's not inappropriate to take 1, 2, 3, 4 years to get yourself out of this jam.
Right, because they don't have to do this overnight. It isn't like they have to this year get to full funding levels. As long as they're moving in a reasonable path to get to the funding levels, and it may be over 2, 3, 4 years, 5 years, as you said, where they're increasing their levels of contributions, it's less painful for the members to absorb small increases than to have no increases and then get hit with a big special assessment. And again, that's where I see the liability hitting, the lawsuits start, is when you follow that model instead of doing, as you're pointing out here, small increases. And so as long as they have some kind of general plan to get there, and they're adding some monies into the reserves, they're in a much better position.
So the consequences are still there. I hear you saying that the board liability exposure starts to go down. So maybe number 5 starts to fade as far as a bad consequence when they're in this middle ground, depending on how far they're going. I see the mortgage difficulties kind of going away when they're in this settling mode, because hopefully they've gotten their reserve contributions above 10% of association total budget. So they're making progress. Adrian, some comments?
I agree. Yeah, and in fact the other 4, the special assessment, deferred maintenance, declining home values, and potential litigation, all start to decline as you are starting to build up, ramp up your contributions into the reserves. So not only do you eliminate the mortgage difficulties, but you also reduce the exposure in the other 4.
Yeah, very nice. So they are making progress. Well, the third phase of this conversation today is on success, where the board is adjusting their budget for full funding contributions. In the illustration that we've used today, it's a doubling of the reserve contributions for this association. But let me suggest and remind the attendees here today that if your association currently is well funded, the recommendation to be fully funded is usually just a tweak. It may be the difference between, instead of coming from $2,500 a month, maybe you were at $4,800 a month or $4,900 a month, and now the recommendation is $5,000 a month. No big deal. So it depends on your perspective, where you're coming from to be able to make this decision. But full funding is a great place to be.
Can't argue with that. Yeah, that is certainly the better position, because you're not going to get sued for over full funding. But you may get somebody who'll complain that we don't need to be at full funding. You know, we should be at 10% or 20% funding. That's all we need, and we can just do special assessments. Okay, well that's not a good position to take. It's always better to err on the side of more funding in the reserves than less. And in fact, what's the typical funding levels nationwide?
You're right on pace. Let me talk some real numbers. Across the country, there's about 30% of the associations that we categorize as well-funded. Well-funded is an association that's in the 70 to 130% range. So a lot of associations are in that category. The associations that we hear about that are in dire straits, those are the associations in the 0 to 30% range. And there's, again, about 30% of the associations across the country in that range. Those are the ones that we hear the most about because that's where the most difficulty is. That's where the most problems are. But let me, again, try to put this in perspective. As far as total budget, operating budget is money that's spent and gone. It has gone away from the association. Reserve funds are the portion of the budget you actually spend on yourself. You're literally turning your reserve contribution cash from cash into paint or into a new roof or into new asphalt. It's a reinvestment in your own association. Basically, you could argue back into the equity. As far as total budget, reserve contributions are typically in the range, full funding contributions are typically in the range of 25%. Depending on the physical makeup of the property, it could be anywhere from 15 to 40% of the association's budget. But that really ends up not being a lot of cash. And again, remember, this is not money that's spent and gone. It's money that gets reinvested in your own association. When we, again, do that math, the $5,000 a month for an 80-unit association was only about $60 per unit per month. And that's about the same amount of money as a premium coffee. It's $2 or $3 a day, and that's not a lot of money to be spending on the major capital maintenance projects at your homeowners association.
Yeah, it's this money you're going to recoup in the end anyway when you go to sell the house, because it goes back into the equity. So, you know, a cup of coffee is worth it. Okay, and as you pointed out here, the consequences, all this stuff goes away. If you're fully funded or close to being fully funded, you're not going to have a problem with special assessments, deferred maintenance, mortgage difficulties, declining home values, or litigation issues. It really makes it, and it's stressful enough for board members as volunteers to be on boards and trying to do their jobs without being threatened with lawsuits. So a small increase, these small increases into reserve contributions really pay off for the association and for boards of directors. It makes their lives a lot easier. Okay, and it satisfies the business judgment rule.
Right. One thing that we try to talk about with our clients is, again, moving past just the financial aspect of their decision, but thinking about what are they doing as far as the decision bar, we call it, on the scale of foolish through casual through wise. Adrian, can you touch on that?
Well, I think it's just you're doing a visual of what the business judgment rule, and that is if they start to make really bad decisions, there are going to be consequences. And, you know, when directors get on boards and they think that they can just, you know, casually make decisions and there are not going to be consequences, they're wrong. There are consequences, and it's better to be being serious about being on the board and taking seriously the consequences of your decisions, because that's the good faith element of that business judgment rule. And if you don't pay attention, if you start making very foolish decisions and get sued, a lot of boards think, well, the D&O will take care of it, our directors and officers liability coverage. Well, they may defend, but with a reservation of rights, in that they're not going to pay for any judgments that may be rendered, and directors may be finding themselves faced with personally coming out of pocket for the consequences of their bad decisions. So that's the foolish end. Now, does that mean that you have to make every decision absolutely correct? No, you don't. As long as you follow those elements of the business judgment rule, you can make a wrong decision and that results in damage and a lawsuit, but you're not going to be personally liable because your decision was done in good faith, best interest of the community, and as a reasonably prudent person would after a reasonable inquiry. So as long as you're following this model, you don't have to do full funding. You can start ramping up to that level, but what you don't want to do is no funding, with the one exception that the market collapses and you have no money. Okay, well, and that's a good reason why you can't do any funding at all.
Right,
but
and
that's not where we are.
Right, that's the extreme case. What we're trying to guide our clients towards and the listeners in today's webinar is an association that's physically, financially, and legally in a good state of health and that looks nice. People, the homeowners are paying their fair share. The board members sleep well, or at least they sleep without concern for liability.
Fear of getting sued. Right.
Right. It still may be a noisy neighbor and the dumpsters down below and that kind of thing, but those are other issues. But this is where we're trying to make sure that people are understanding that it's not just a financial decision. There's legal implications to the budget decisions that they make. Well, we're getting close to the end of our time here and want to thank everyone for taking the time to attend. If you like the kind of content that you've heard so far, I encourage you to go to www.reservestudy.com for more reserve study information, or for legal assistance, go to Adrian's website, adamskessler.com. If you want to get signed up for a great newsletter, Adrian has a national newsletter. He does address a few California issues, but it's a great national information on community association. It comes out Sunday mornings. Go to davis-sterling.com, sign up for his newsletter. You may have heard about this webinar through his newsletter, or if you want to sign up for some more information about reserve studies, the helpful hints, insights, again, the ways to help understand how your reserve study can make life better at your association, go to reservestudy.com. And on the right side of the page, you'll see an opportunity to sign up for the email list for association reserves. Well, on behalf of Adrian and myself, I want to make sure that you understand we love doing this. We understand that education is part of what we do. An educated board member, manager, or industry professional is someone who's going to make better decisions and move this industry forward. So with the time we have left, Paige, can we turn it over to you for questions?
Absolutely. Thank you, Robert and Adrian. As I mentioned earlier, you can ask either our presenters a question by typing your question into the question box at the bottom of your control panel. We'll just dive right in. The first question is from Giselle. If previous boards have not reserved funds properly, is the current board liable?
Well, not the board of directors, the current directors. The association may still be liable in some fashion, and there's still the risk of litigation, but the directors who come on board now are not going to be responsible for the decisions of prior directors. They're going to be responsible for the decisions they make now. So if the prior boards underfunded the reserves, the current board needs to do something about that. Paige? Are you there?
Okay. Next question is from Douglas. Yes, next question is from Douglas. Are we legally allowed to add items to the reserve study that have a longer than 30-year useful life?
Certainly. There's a 4-part test in National Reserve Study Standards that dictates what is appropriate to be listed in your reserve study. Number 1, it needs to be a common area maintenance responsibility. Number 2, it needs to have a limited useful life. Number 3, it needs to have a predictable remaining useful life, so you know where it is on the scale and you can see it coming. And number 4, it needs to be above a minimum threshold cost, so it's not something that would be more appropriately handled in the operating budget. So in National Reserve Study standards, there's no limit to something being within 30 years. We see roof systems, elevators, major significant elements of an association that typically have a useful life or design useful life past 30 years. Those are very appropriate to appear in your reserve study. Paige?
Yeah, I'll add to that. The 30-year comes from, at least in California, in the Davis-Sterling Act. The associations are not required to list any components with a useful life over 30 years, and that is often a mistake. What will happen is they'll list the components they can see, things that are less than 30 years, and then from year to year to year, 10, 15, 20 years later, they're still using the same list of components. They've never added the ones that are over 30 years, and those will sneak up on them and suddenly start to have issues with those. So listing all the major components is a good idea, and then you can decide, per your own state's laws, what you'll fund, and others may be simply place markers holding a place in the component list until it gets to a point where you need to start reserving for them.
Okay, next question is from Terrence. What happens if there are restrictions in the CC&Rs or bylaws to how much HOA dues can be increased each year?
Oh, well, I can tell you in California, they're null. There is no impact, no effect on those. At least in California, the state law, the Davis-Sterling Act, voided all of those so that boards could raise their dues and then set limits within the statute of special assessments, 5%, 20% on regular dues increases. There may be similar kinds of statutes in other states. I don't know.
Okay, next question is from Richard. What is the minimum threshold of cost of a reserve component?
Good question. In that 4-part test, I indicated it needs to be above a minimum threshold cost of significance. Often, for the average association, that ranges in the area of 0.5% to 1% of their total budget. It may vary at your association. It might be the board member's signature authority or the manager's signature authority, but for most associations that tends to be somewhere in the range of 0.5% to 1% of the association's total budget.
So you're not putting little things like light bulbs in the reserve study. Those
Correct.
should be in the operational budget and just be a part of their ongoing buying new light bulbs and those kinds of things. It's the larger components that you care about. Those are the ones that you need to be reserving for.
Correct. The ones that would otherwise unsettle the operational budget.
Right. Paige?
Okay, next question is from Bruce. If the board discovers something that wasn't identified as a reserve component during the previous on-site study, can this be added before the next regular on-site reserve study?
Let me...
Robert, you can take that.
Yeah, you asked a couple of things there. A reserve study is typically something that is done once a year. You typically don't reissue it mid-year. So my recommendation is to, as soon as you identify it, either get back in contact with your professional and see if you're still within a time period where you can still revise it and get it out for that budget year. The other element of that was there's different types of reserve studies. There's a full reserve study that an association should only need to have to do once, and these are, again, National Reserve Study terms. The person asking the question talked about a with site visit reserve study. There's also a third type of reserve study, which is an update no site visit. We add components in an update no site visit all the time. It may be splitting a component by phasing it. It may be adding something that was previously unknown. You don't have to wait for a with site visit update to add or drop something that is inappropriate from appearing in the reserve component list. Make that change every time you update the reserve study, no matter what type of reserve study update you get.
I agree.
Okay, time for one last question, and it's from Albert. What is the deciding factor when a reserve study is required in California? Is it based on number of units, annual budget, or something else?
It sounds Deciding factor on what? On whether one is done or not? Or what's the question? Robert, did you understand that?
Yeah.
Whether a reserve study is required.
Is required. Well, they're required. It doesn't matter. You're required to do it by statute. You're required to do a reserve study. So if you're an association with common area elements, well, okay, let's say you're an association that has only in one lot it's got grass on it, and that's it. That's the only reserve, the component they have, common area component. Then there probably isn't any need for a reserve study. Robert, what do you think?
Yeah, I think there's in California. I'm trying to recall my my California Civil Code here, but I think there are two exceptions. One is when the value of the common area assets are less, the total value of the common area assets are less than half of the annual budget, which is just that illustration that you were talking about, a planned development, and maybe all they have is a entry sign. Then
Right.
that does not trigger the reserve study. And number two, I believe that commercial condominium associations, primarily for commercial purposes, they are not required to have a reserve study. I think they presume that those types of owners would do it intuitively because they're business people.
Yes, they're supposed to be more sophisticated than regular homeowners. And so the legislature is protecting homeowners by mandating the reserve studies. So if you're a condominium association, you're going to have common area components that need reserving. If you're a PUD, you might not. So you'll then Robert's right on the statute. That sounds right on what the two exceptions are.
Okay, thank you, Robert and Adrian. That concludes our webinar. If anyone is interested in a recorded version of this or any other webinar, you can search for them on YouTube or on the Association Reserves webinars page. If you enjoyed today's session and would like to receive the speakers' newsletters or receive announcements of future webinars, I remind you to please visit their websites and sign up to receive their newsletters. As you exit this webinar, a survey will display. If you could help us out by completing the survey, we'll be happy to email you an outline of the webinar, and that will include questions that were not answered during this session. I want to thank you all for attending. If you have any questions or if there's any way we can be of service to you, please don't hesitate to contact us. Thank you again. Goodbye.